Dissolution of co-inheritance. Dissolution between heirs is a procedure designed to divide their share in the estate in a fair and agreed manner to the various heirs. The purpose of this process is that a forced and artificial partnership built and created between the heirs regarding the estate assets of an inheritance will come to an end. If that were to happen, the procedure of what must then be done is written here. According to Section 121 of the Inheritance Law, it is stipulated that the process of dissolving a partnership between heirs will be carried out by the heirs themselves, and if they are unable to reach an agreement and divide the inheritance on their own, an estate administrator will be appointed to do so. In any case where there is a need and desire to perform a joint liquidation between heirs, it is advisable to seek legal assistance and assistance from a lawyer who specializes in real estate law, inheritance and partnership liquidation, in order to carry out the procedure correctly and quickly, without unnecessary disputes and delays. In which cases is it necessary to carry out a process of dissolution of a partnership between heirs? In cases where the heirs fail to reach an agreement regarding the dissolution of the partnership and the manner of division of the property, it is possible to dissolve a partnership in real estate or apartment between the heirs through a legal agreement, as well as by going to court and filing a claim for liquidation. A common example of a situation of partnership between heirs that is forced is a registration of the heirs as owners of rights in the land belonging to their parents who died in an equal division. If all these ways do not lead to an agreement between all the heirs, then it will be inevitable to go to court. In any application to the court regarding the dissolution of a partnership between heirs and division of an estate, it is recommended to receive legal advice and representation from an experienced lawyer who specializes in the field of division of inheritances, real estate law, and dissolution of partnerships. In the case of a claim to the court, the power to hear claims of a type of dissolution of a partnership between heirs is vested exclusively in the family court. Partnership in estate assets. After the death of the deceased, all his assets become part of his estate. However, the estate is not considered and defined as a legal entity, and is therefore required to register the assets included in the estate in the name of the heirs. The rights and the share that the deceased left behind for each of the heirs in the estate are determined in a will or inheritance order in accordance with the provisions that appear in the order. The order of inheritance or the execution of the will show the share of each heir in the assets included in the inheritance. The registration procedure and action may give rise to and create various problems and difficulties in cases where the heirs refuse or do not wish to be in a partnership relationship with the property or properties they will inherit. Such a dispute in the act of registration may even have an impact on the issue of tax liabilities when the heir seeks to sell in the future the share he inherited in the land. In most cases, the difficulty arises when the heirs inherit various rights in the land, such as a residential apartment or a plot of land. In view of the provisions of the real estate law, which stipulate that a person may not be required to be a partner of another person. Ways to divide an estate between heirs. Regarding the division of inheritance and estate between heirs, a distinction must be made between the division of the estate in the process of liquidation of real estate and liquidation of inheritance in the case of movables, which is a simpler and shorter procedure. In most cases, because movables such as money can be divided among all heirs, it is more complex and difficult to distribute rights in real estate between the heirs, and many times this difficulty can create disputes between the heirs. The conditions for carrying out a liquidation procedure between heirs. Prior to the distribution of the estate to the heirs, the inheritance law requires and stipulates that the deceased's creditors must be contacted in order to pay his debts if such exist. Dissolution of a partnership in inheritance assets will be carried out only after repayment and payment of all debts. It is important to note that the heirs will be responsible for the debts of the estate up to the amount of their share, i.e., if the estate has already been divided, and it later turns out that there is still some debt left to the unpaid deceased, the heirs will have to pay and repay the debt from their share to creditors.
Liquidation under an estate division agreement or an agreement between heirs. Pursuant to Section 122 of the Inheritance Act, it is stipulated that the administration of the estate and the manner of its distribution by the heirs must be conducted and carried out with consent. The heirs' agreement regarding the manner of division of the inheritance will be backed by an agreement made and signed between the heirs or an estate division agreement. A liquidation procedure in this way will allow the heirs to choose and decide how the rights in the land will be registered in the inheritance, even if the will or the order of inheritance specifies and determines a different division arrangement. Undoubtedly, liquidation of inheritance rights and sharing heirs by way of an agreement is the best and cheapest way in most situations and cases in view of the savings in legal representation costs, time, and because in this way it will be possible to make proper tax planning and save heirs high tax payments to various authorities in the future. And they will decide to sell their share in the land given to them by inheritance. Division in the eye of inheritance. The procedure of dissolving a partnership between heirs through division in kind is common and accepted, especially when it comes to the distribution of movables such as objects or sums of money of the deceased. Movables can be divided by eye when they can be separated, for example, when it comes to sums of money. For example, 4 heirs win 1 million shekels, and there is no difficulty in dividing this amount into 4 equal parts, so that each heir will receive 250,000 shekels. The distribution of movables such as furniture or other valuables is also relatively simple, with, in most cases, each heir receiving objects that are close to his heart and that he prefers. If there is a significant and substantial difference in the value and worth of the objects received by one of the heirs compared to the other heirs, then the difference can be balanced and the gap bridged by way of balance payments. Division of the estate according to fate. When it comes to assets and objects that cannot be divided or sold in kind, they will be divided according to fate.
Filing a claim for dissolution of partnership between heirs. If the heirs fail to reach understandings and agreements among themselves, and in cases where one of the heirs acts on his own initiative and unilaterally, a step prohibited under Section 122 of the Inheritance Act, or when the division of the estate significantly impairs his value, and when creditors file to claim their debt from the estate to the court, then there will be no choice, and there is no choice but to go to court and file a lawsuit to dissolve a partnership between heirs. The purpose of filing a claim in court in the process of dissolving a partnership between heirs is to reach a division of the estate according to instructions given by the court. The court, in this context, directs the heirs how the partnership will be dissolved, and in general, will appoint as executors the power of attorney of all parties for the purpose of implementing the dissolution of the partnership. The appointed administrators of the estate will be responsible for the sale of the estate's assets, as well as for the dissolution of the partnership that took place between the heirs through an agreement and arrangement signed between the heirs that will be submitted to the court for approval. Balance payments in the process of dissolution of co-inheritance. Balance payments in the process of liquidation of a partnership between heirs constitute one of the ways for the correct and fair implementation and division of the property between the heirs. In the event that the share in the property of one of the heirs is greater than the share of another heir, the court will be entitled to demand from the heir who won a larger share and order him to transfer balance payments to the other heirs in order for the distribution to be fair and equitable. Dissolution of an apartment partnership. In most cases, it is not possible to carry out a process of dissolving a partnership in an apartment between several heirs unless it has been agreed between them that one of the heirs will receive the apartment and compensate the others through balance payments to the heirs. The court may order the heirs that the dissolution of the partnership be by way of a sale at the maximum price. Dissolution of a share in agriculturally based property. Section 114 of the Inheritance Act provides that in the event of a share in an agricultural farm, in the absence of an order given by the testator, the farm shall be given to an heir who is able and willing to maintain it, and he shall transfer adequate compensation for the surplus received to the other heirs. If the heirs do not reach regarding the identity of the heir who is supposed to receive the form of compensation for the farm, or what the value of the farm is, the family court will decide the dispute.
Dissolution of an inheritance partnership in Israeli law. The procedure for dissolving an inheritance partnership is required in cases where the heirs seek to divide the estate assets among themselves by dissolving the partnership and the assets they will inherit. The process of dissolution of the co-inheritance can be carried out by consent through the drafting of an agreement between the heirs, and if the heirs do not reach an agreement, then it is necessary to file a claim with the family court accompanied by an inheritance lawyer specializing in real estate and liquidation of inheritance partnerships. The claim within law for the dissolution of the real estate partnership between the heirs may be filed by any of the heirs even without obtaining the consent of the other heirs. The procedure of dissolution of a partnership constitutes a basic right that is legally granted to each heir. The law in the State of Israel encourages the dissolution of a real estate partnership due to the heaviness and burden created by the partnership in all matters relating to the proper utilization of the real estate. Procedure for dissolution of a partnership between siblings. When it comes to the process of dissolving a real estate partnership between brothers who co-own a residential apartment, which was given and inherited to them, the heirs are granted a right-of-way and the option to purchase the apartment. According to the inheritance law, an internal bidding is to be made between the heirs regarding the apartment when the co-inheritance is dissolved, and the apartment will be sold to an heir who offers the higher price provided the price offered is not lower than the market price. Control: where none of the heirs is interested or agrees to purchase the property, it is possible to sell the apartment to a third party, the third party who offers the highest price, and then the proceeds from the sale will be divided among the heirs. Dissolution of consent agreement. If there is cooperation and agreement between the joint heirs in the property, then the liquidation process is expected to be simple and easy and will be done after a written and signed agreement between the parties, accompanied by a real estate and inheritance lawyer, or alternatively by a partner leaving the partnership by selling his share in the property. Filing a claim for dissolution of partnership between heirs. The law of the State of Israel stipulates that any partner in real estate that is joint will be entitled, at any time, to request and demand the dissolution of the partnership on the basis and from the legal concept that treats real estate as a kind of temporary situation that is not optimal for real estate. Therefore, many claims for dissolution of a partnership between heirs in real estate are accepted in cases where one of the partners thwarts and prevents the dissolution of the partnership. If the claim for dissolution of the partnership is accepted by the court, it will issue an order for dissolution.
The nature of the hearing in the process of dissolution of a partnership between heirs. In the case of a real estate property, it is necessary to register the partner's rights to the property. Once the rights have been registered in the land registry, a claim can be filed in the magistrate's court for liquidation. If the land is not registered in the land registry, taboo, but in the Israel Lands Administration or a contracting company, the claim must be submitted to the district court or the magistrate's court in accordance with the value of the properties, when the provisions that apply to them are according to the movable property law. In the event of a family dispute, the claim will be submitted to the family court. Professional legal advice and representation in the field of real estate and inheritance. Pawn Law Office and Notary is considered one of the leading and largest law firms in the field of real estate, inheritance, and civil commercial law. The firm's staff includes senior, skilled, and experienced lawyers and attorneys who will accompany you in a personal approach, step by step throughout all stages of the real estate transaction. Realization of a will and inheritance or dissolution of partnership between heirs, until the task is completed smoothly, quickly, and best. The accompaniment, representation, and legal advice we provide to our clients is the difference between failure and heartache, and optimal management of the procedure without taking unnecessary risks and the formation of disputes. We invite you to seek the help of our team of experienced legal experts who are at your service, so that you can be assured that you will receive the highest quality and most professional legal answer.